Hello everybody, and welcome to History Bite number 246, dated May 5th, 2021. I'm Walter, your mobile historian and blue-collar scholar. This History Bite is entitled The Brotherhood of Chief Justice Earl Warren and Justice William J. Brennan Jr. Now, for those who are unaware, Chief Justice Earl Warren and Justice William Joseph Brennan Jr. served on the Supreme Court of the United States together from October 1956 until Warren's retirement in June of 1969. When Brennan arrived at the court in October 1956, Warren had already been there for the better part of 3 years. Okay? So these two judicial legends, two of my favorite jurists of all times, by the way, had arguably a more profound impact on the law than any other two justices in history, with the sole exceptions of Chief Justice John Marshall and Justice Joseph Story, both in the 19th century. And piggybacking off of that, Chief Justice Warren and Justice Brennan also shared the closest relationship between a Chief Justice and an Associate Justice since the days of Chief Justice Marshall and Justice Story, okay? So these two had an incredible chemistry and like-minded legal philosophy that solidified that bond, okay? Both Chief Justice Warren and Justice Brennan strongly believed in equal protection of the laws, due process of law, and equal justice under law for everybody, not just the wealthy and the powerful, all right? They believed that all Americans, regardless of race, religion, creed, color, didn't make a difference, deserved these concepts as required by the Constitution, okay? And as such, Chief Justice Warren and Justice Brennan rarely found themselves at odds with one another on legal issues of the day, okay? The very few areas where Warren and Brennan didn't see eye to eye were with respect to the protection of pornographic material under the First Amendment. They didn't quite see eye to eye on flag burning, and they also didn't quite see eye to eye on the protection of gay Americans under the law, okay? Now, keep in mind, I said that they believed strongly in equal protection, due process, and equal justice under law. And certainly both believed in that concept for everybody. But with respect to conduct and homosexual conduct, gay conduct, Chief Justice Warren was a bit more conservative in that regard than Justice Brennan. Okay, Justice Brennan didn't have misgivings about gay petitioners seeking equal protection that came to the court. But Chief Justice Warren was very hesitant to establish constitutional protection for homosexual conduct. Keep in mind, this is the 1950s and 60s, so Warren's views were certainly not anything out of the norm. It was Justice Brennan's views that were very radically to the left and very out of touch with the prevailing norms of the day in that regard, okay? So that's with respect to gay issues. Now, with respect to protection of pornography, let's make one thing clear. Both Chief Justice Warren and Justice Brennan generally had a great distaste for pornographic material, all right? But that didn't stop Justice Brennan from giving it constitutional protection, to a very large extent. Not absolute, but to a very large extent. Whereas Chief Justice Warren was very reluctant to give any constitutional protection to pornographic material, okay? He was very squeamish about pornography, all right? And with respect to flag burning, even though that issue, never directly came before the court, as to whether or not there's a direct First Amendment ability to burn the flag as speech. Brennan certainly, as evidenced in the case of Texas versus Johnson, some 2 decades after Warren left the court, supported the ability to burn the flag as a means of political protest, whereas in the one case where the court even slightly gazed on the subject, Street versus New York, where it didn't directly address the flag burning issue in that case, Warren chastised the majority for not addressing the issue, and certainly would have voted to affirm any conviction for burning the American flag. Warren did not think that that was in any way, shape, or form protected by the First Amendment to burn the flag. And in that regard, I certainly agree with Chief Justice Warren. I do not feel that flag burning should be protected by the First Amendment. Love my flags. This cherished emblem means a lot and should not be protected under the First Amendment. I mean, should be protected under the First Amendment. Burning the flag should not be given First Amendment protection, all right? You know, I think there are more credible ways to express political protest and outrage than burning the flag. Like I've always said, wash it, you know, but don't burn it. We've got problems, but they don't need to be burned. Wash away the problems, okay? But anyway, back to subject, all right? In the areas that Chief Justice Warren and Justice Brennan did not see eye to eye, I firmly agree with Justice Brennan in everything but the flag burning, all right? You know. So Chief Justice Warren and Justice Brennan, like I said, you know, from the early days that, you know, the two would serve together, had an incredible chemistry, all right, that is not a given. You know, chemistry has to often be developed, and sometimes between justices it never develops. But Warren and Brennan had a chemistry that would serve them well, you know, in the 13 years that they served together on the Supreme Court. From Brennan's early days on the court, you know, Warren recognized his skill at building coalitions, okay? That is, bringing together justices whose views were normally at odds with each other, all right? And Brennan was able to bring these justices together to get a majority opinion. Warren, being the political mastermind that he was, you know, even as Chief Justice, certainly saw the usefulness of Brennan and, you know, aside from the usefulness, you know, latched onto him just as a downright, you know, smart and very friendly guy, to say the very least, you know, and the two formed a friendship that would last for the next almost, you know, darn near 20 years, even after Warren left the court, all right? And Warren and Brennan, you know, being, you know, almost and completely like-minded, you know, with respect to their legal views, emphasizing areas such as civil rights, okay, civil liberties, okay, you know, and don't forget protection of the accused, all right, defendants' rights, which was the highlight of the Warren court era. You know, Warren and Brennan formed a powerful voting bloc that they would use to manipulate, in a good way, those 5 votes needed to get majority opinions, all right? Brennan's taskmaster skills, you know, at building coalitions is not something that can be overstated. The guy was a genius. And even though to build those coalitions, you know, he, you know, had to quite often water down his views to get the recalcitrant justices to go along with it, he still got it. One of Brennan's most famous sayings when he was on the Supreme Court was, with 5 votes, you can do anything around here. And that's a truism. All it takes at the Supreme Court is 5 votes, and you can carry the day. And Brennan was willing to do almost anything to get those 5 votes. And he did. Like I said, the guy was a political mastermind as a Supreme Court justice, which is why his impact on the law, okay, was so profound. Like I said, on the court, Brennan would end up writing some 1,360 opinions, all right, only exceeded by his colleague, Justice William O. Douglas, who wrote about 1,375 majority opinions on the court. All right, Douglas and Brennan hold the record of writing the most opinions on the Supreme Court in the court's history. All right, so Warren and Brennan, like I said, in their unique bond as Chief Justice and Associate Justice, was, of course, observed and noticed by their colleagues throughout the 13 years they served together on the Supreme Court. And for sure, Brennan's role in influencing Warren and being arguably his closest confidant in those 13 years on the court together often led other associate justices to call Brennan vice chief and deputy prime minister. That's how much influence Brennan had over Warren. You know, Brennan was also the intellectual force behind a substantial amount of Warren's opinions, okay? Chief Justice Warren was a highly intelligent man, but he was not what you would call a legal intellectual, all right? You know, Warren had been a politician, all right? And, you know, he had not, I guess you would say, developed the type of personal and professional legal intellect that you have seen in a lot of other Supreme Court justices, but that's fine. Warren's strength, okay, was in his leadership abilities on the Supreme Court. He was the leader of the Warren Court. You know, as a politician, he knew how to bring people together as well. Not as much as Brennan could, but he certainly knew how to do it. Okay, one of the greatest examples of Warren's political leadership abilities, as evidenced on the court, was him bringing together all 9 justices in Brown versus Board of Education. We all know about that case, all right? That was his shining star moment on the Supreme Court, followed by many more, all right? But in any case, yes, Brennan provided a substantial amount of the intellectual power behind many of Warren's prominent opinions that we've all heard of. Arguably the most notable one being Miranda versus Arizona. Okay, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided to you, you know, so forth and so on. That's Miranda versus Arizona. Brennan provided a substantial amount of the intellectual authority behind that opinion, even though Warren himself was the author of Miranda versus Arizona, 1966. All right. 2 other Warren era opinions that Warren himself was the author of, that Brennan provided the intellectual force behind, were Terry versus Ohio, 1968, the famous stop and frisk case. You know, if a police officer believes a crime is about to be committed, has been committed, or is in process of being committed, you know, the stop and frisk, all right? As well as United States versus O'Brien, the case about burning one's draft card as a means of political protest, all right? Terry was a 4th Amendment case. Like I said, a crime has been committed, is being committed, or is about to be committed. Stop and frisk, very important 4th Amendment case regarding law enforcement ability to stop and frisk you for potentially dangerous weapons and other things on your person, all right? As well as U.S. versus O'Brien, 1st Amendment case, you know, whether or not you could burn your draft card legally as a means of political protest. In both cases, the court sided with the government, okay? Terry, the court ruled in favor of Ohio, all right? And in U.S. versus O'Brien, the court ruled in favor of the U.S. government. All right, keeping in mind this is the late 1960s, and a lot of the riots, 68 riots, and a lot of other lawlessness going on in the country at the time. So the court did not think it was in the best interest, obviously, of anybody to be weakening the power of the government during these turbulent periods. Okay, 1968. 67 through 69, woo, rough times in the United States of America. So the decisions of the court reflected that. Okay? So Warren provided a substantial amount of intellectual force behind those decisions. All right? Those are just 3. But there were many more that Warren provided the Brennan provided the intellectual force behind. Okay? Now, these two, for the record, being that they were so close, talked a lot and exchanged views, both at conference and outside of conference. A common tradition of Chief Justice Warren and Justice Brennan was to hold pre-conference meetings, where they would discuss their views on particular cases and make them known to one another. And the two would theoretically plan a strategy to be able to convince other, unrelenting, more conservative justices to go along. Now, Warren and Brennan arguably were the two most liberal members of the Supreme Court in the period between 1956 and 62. After 62, they were joined by members of the court who were just as liberal as they were, if not even more liberal, such as Arthur Goldberg. All right? But, these two would adopt their strategy and then pounce on weaker associate justices, as it were, to see if they could bring them in the majority. And in a great many cases, they were successful. In other cases, they were not so successful. All right? Brennan and Warren didn't do a whole heck of a lot of dissenting while they served together on the Supreme Court, as there were plenty of other fellow liberals on the Supreme Court during that era. Okay? And, the times always influence actions on the court, all right? So when Chief Justice Warren decided to wrap up his time on the court and announced his retirement to President Lyndon Johnson, although he would ultimately be replaced by Richard Nixon. That's covered in the video about the Abe Fortas debacle, okay? Warren privately confided to Brennan that he wanted Brennan to be his successor as Chief Justice. All right, even though they knew that was not going to happen because President Lyndon Johnson was determined to appoint his crony, Justice Abe Fortas, to the court's center chair, which, had Fortas been confirmed, would have been far more disastrous than many people realize. Fortas was anything but Chief Justice material. And even though he's a fellow liberal like myself, I think we did better under Warren Burger, who ultimately was Warren's successor, having been appointed by President Nixon in 69. For all of Warren Burger's faults and ineffective leadership abilities, incredibly ineffective leadership abilities, great innovator, yes, but leadership, not his best trait. He probably did the country a far greater service than Abe Fortas ever would, all right? And, Abe Fortas' nomination was a disaster. But in any case, back to the subject, Brennan knew that Johnson would never nominate him to be Chief Justice because the two weren't particularly close. And, Brennan would have just been probably too liberal for Senate Judiciary Committee to accept. I mean, he had been the author of a great deal of the Warren Court's decisions, okay, that had completely upended American society as it was known at the time. So it's highly unlikely that they would have given him a substantially easier time than they gave Abe Fortas. What they would not have had to use against Brennan had he been nominated to replace Earl Warren as Chief Justice were all the ethical violations that Abe Fortas had engaged in during his 3 years and some change as an associate justice from 65 to 69. Okay? The worst they could have thrown at Brennan was his decisions, but if you're going to hold a judge's decisions too much against them, then you are threatening to undermine the independence of the judiciary. Okay? So I think, my personal view, if Chief Justice Warren's wish had been granted and Brennan had been nominated to replace him, Brennan may have indeed been confirmed. It might have been a little rough, but I think ultimately, Richard Russell and Senator Dirksen would have pretty much guided Brennan through the process. Okay? So, like I said, the friendship between Chief Justice Earl Warren and Justice William J. Brennan Jr., was a powerful one. The closest bond between any chief and an associate justice since the days of Chief Justice John Marshall and Justice Joseph Story in the 19th century. All right. These two judicial legends, liberal giants of the 20th century, okay, had a more profound impact on the law, arguably, than any other members of the court in the 20th century. All right. Like I said, Brennan and Warren have always been among my favorite justices. And, they did not let precedent or seemingly outdated views stand in their way of remedying a wrong of any kind. Another one of Brennan's favorite sayings was, every legal wrong had a legal remedy. All right. And my favorite Brennan saying is that the genius of the Constitution lies not in any static meaning that it may have had in a world that is long dead and gone, but in the adaptability of its principles to cope with current problems and current needs. The Constitution is a living, breathing document that could fix society's problems. And that is a very progressive view that is shared by many federal judges and politicians, but it is scorned by just as many. All right, as a very activist philosophy, allowing judges to do whatever they want, just providing the balance there. Okay, Chief Justice Warren, of course, shared that philosophy. All right, one of Warren's most famous quotes was, with respect to his enforcement of defendants' rights, was that we were merely enforcing the Constitution against the states. All right, and that's exactly what they were doing. But the Warren Court to this very day is still derided as a very activist, out of touch court. But nonetheless, it is arguably one of the most, if not the most influential period in U.S. Supreme Court history. Okay, so that pretty much concludes the Brotherhood of Chief Justice Earl Warren and Justice William J. Brennan Jr. If you have any questions or controversies, you can leave them down below and I'll be happy to answer them. Okay, if you like this video and learned a thing or two from it, drop me a like. I'd appreciate that. And if you've not subscribed to my channel, I would truly appreciate if you did so now. Just hit that little red subscribe button and we'll be in business. It's totally free and you'll get updates on when I post new videos. All right. So take care. Stay safe out there. Be blessed. And I'll talk to you at the next bite. Peace.